facing the police every single day.
Concluded in the 1989 case of DeShaney versus Winnebago County Department of Social Services that, as a general matter, the Due Process Clause does not create a state duty to protect an individual against injury caused by a third party. However, the court also noted that, quote, when the state takes a person into its custody and holds him there against his will, the Constitution imposes upon it a corresponding duty to assume some responsibility for his safety and general well-being. The court further explained that, quote, the affirmative duty to protect arises from the limitation which it is imposed on his freedom to act on his own behalf. It is the state's affirmative act of restraining the individual's freedom to act on his own behalf through incarceration, institutionalization, or other similar restraint of personal liberty, which is the deprivation of liberty, triggering the protections of the Due Process Clause. Still, as the
Court holds gun ban for felony defendants unconstitutional. Published on Tuesday, September 20, 2022. A federal law banning those under felony indictments from buying guns is unconstitutional, a federal court in West Texas ruled Monday. Article available here, link is external. The court dismissed a federal indictment against Jose Gomez Quiroz that had charged him under the federal ban of obtaining a firearm while under indictment and noted it was unknown whether a statute preventing a person under indictment from receiving a firearm aligns with this nation's historical tradition of firearm regulation. According to the court, Quiroz was under a state burglary indictment when he tried to buy a handgun and challenged the ensuing federal charge. In a 25-page opinion filed in Pecos, Texas, the court acknowledged this case's real-world consequences. Certainly valid public policy and safety concerns exist. However, he said a Supreme Court ruling this summer in New York Rifle and Pistol Association v. Bruin, link is external, framed those concerns solely as a historical analysis. Although not exhaustive, the court's historical survey finds little evidence that the federal ban, which prohibits those under felony indictment from obtaining a firearm, aligns with this nation's historical tradition. The Second Amendment is not a second-class right, the court ruled. No longer can courts balance away a constitutional right. Facts of the case. The state of New York requires a person to show a special need for self-protection to receive an unrestricted license to carry a concealed firearm outside the home. Robert Nash and Brandon Cook challenged the law after New York rejected their concealed carry applications based on failure to show proper cause. A district court dismissed their claims, and the U.S. Court of Appeals for the Second Circuit affirmed. Question: does New York's law requiring that applicants for unrestricted concealed carry licenses demonstrate a special need for self-defense violate the Second Amendment? Conclusion: New York's proper cause requirement violates the 14th Amendment by preventing law-abiding citizens with ordinary self-defense needs from exercising their Second Amendment right to keep and bear arms in public for self-defense. The right to carry a firearm in public for self-defense is deeply rooted in history, and no other constitutional right requires a showing of special need to exercise it. While some sensitive places restrictions might be appropriate, Manhattan is not a sensitive place. Gun restrictions are constitutional only if there is a tradition of such regulation in U.S. history. Justice Samuel Alito authored a concurring opinion arguing that the effect of guns on American society is irrelevant to the issue. Justice Brett Kavanaugh authored a concurring opinion, in which Chief Justice John Roberts joined, noting that many state restrictions requiring background checks, firearms training, a check of mental health records, and fingerprinting, are still permissible because they are objective, in contrast to the discretionary nature of New York's law. Justice Amy Coney Barrett authored a concurring opinion noting two methodological points the court did not resolve. Justice Stephen Breyer authored a dissenting opinion, in which Justices Sonia Sotomayor and Elena Kagan joined. Justice Breyer argued that states should be able to pass restrictions in an effort to curb the number of deaths caused by gun violence, and the court's decision severely burdens the state's efforts to do so.